Good afternoon, everyone, and welcome to the latest of Fieldfisher's Data and Privacy webinar series. My name is Renzo Marchini, and I'm a partner in the team here in London. Thank you so much for joining us. Now, we're going to be somewhat bucking the trend today by not talking about AI. Indeed, we're talking about a new legislative initiative from the European Union, which was going through the process at the same time as the AI Act, but perhaps surprisingly didn't get quite as much attention and public discussion as the AI Act itself, despite there being many repercussions for a lot of people holding data, both in the connected device world, but also in the cloud computing world. The Data Act is part of the EU's Digital Reform Initiative and will apply to many in the connected device sector and also data processing services companies, which I'll talk about a bit later. Its main aim is to improve access to data within the EU market for both individuals and businesses. So there's a key difference from GDPR, as we will see. And a motivation, and here I'm quoting from EU Commission press release, is to release data to foster innovation and economic growth and to create a fair and innovative data economy. The Commission hopes that the rules and access of data would inspire an aftermarket. So you don't need to go to the original manufacturer of a connected device and perhaps get your device serviced by even an unauthorized third party in a secondary market. That third party needing the data in order to analyze the problems and service the device. The example that the Commission give is of a bar, a cafe with a smart coffee maker, which measures the amount of water that is used. And therefore, the owner of the coffee bar and anyone that they might want to engage to service the coffee maker might have access to the water usage data. I am joined today by two colleagues with whom I've already begun working closely on some of these issues for some of our clients. Nuria Pastor is a director in our team, and Chloe Abbott is an associate, and we will be playing tag team as we go through our presentation. We will finish within the hour, that is at 5 p.m. in London. I know some of you are not in London or the UK. Before we come on to substance, a few housekeeping points. Please do ask us questions as we go along. I might take them as we at the appropriate point, but also there should be some time at the end. And if there isn't, if we run out of time, then we'll try to follow up soon in writing. You will receive a copy of the slides. Indeed, this is being recorded. You'll receive a link to the recording, which is then also posted on our YouTube channel. So you don't need to scribble down everything as we go along. So what we're going to be talking about then, we'll talk about the timeline. The Act is in force, but there are some transitional provisions. We'll talk about what does it do, what does it aim to do, what data is affected, the relevant types of actors within the framework that this will apply to. We'll talk about the access right, which is the key right that's in the Data Act. And in doing so, we will compare it with the access right that a lot of you in the privacy world certainly will be familiar with, the access rights and the portability rights under GDPR. We'll also talk about data access in exceptional circumstances from public bodies. Cloud switching, which is a separate topic from what's gone before that we'll cover, is the attempt by the EU legislature to solve a perceived problem of lock-in in certain cloud service provisions. There's lots in the Act about certain types of cloud service providers. There are provisions in relation to law enforcement access to non-personal data, provisions in relation to IP rights. We'll conclude and wrap up by giving you some pointers and summarize the sorts of things that you ought to be doing as we go towards the key dates. So what is the timeline then? So the Act was adopted in January this year, and it set out a transitional period up until 12th of September 2025, when most of the rights and responsibilities that we're going to be talking about will take effect. Some things, in particular specific provisions relating to product design of a connected device and manufacturing changes, will only apply from 1 year later, that's September 26. And lastly, some provisions concerning unfair contractual terms, which are dealt with in the Act, won't kick in until September 2027. Now, some of these bullets here, bubbles here, are a little abstract, but we'll shed some light in it, and at the end I'll summarize the timeline again. Nuria, I'm handing over to you.
Thank you, Renzo, and good afternoon, everyone. So as Renzo says, the first thing that we want you to look at is, what does it actually do? What does this act cover? So it does actually a number of things, a variety of things. And what we will focus on today is what we could call the three big ticket items, or the three big ticket themes, which are the ones on the slide. So the Data Act facilitates access to data and data sharing between different parties. And to do that, it creates a data sharing framework whereby users of connected products or related services have the right to access the data and request for the data to be shared with third-party recipients of their choice. So what are connected products and what are related services? These terms are defined in the Act, but Renzo has already given an example. So in broad terms, connected products will be Internet of Things products, such as the connected coffee machine that Renzo mentioned, or perhaps a connected car or a connected fridge. And also in other specific sectors, such as the health sector, it could be a connected heart monitor. So it will affect a broad scope of sectors with connected products. And with regards to a related service, this is a digital service which is linked to the product, and it might be either a service without which the product won't work fully, or it might be a service which adapts or adds to the product's functionalities. So as you can see, I've only given you sort of a high-level explanation because, as you can see, the definitions in the Act are very broad. So many products and many digital services will fall under these definitions. The second thing that we wanted to mention, and as another thing that the Data Act covers, is a mechanism whereby public sectors, EU public sectors bodies may gain access to data. This may only happen in case of exceptional need or under exceptional circumstances. And I will cover these in more detail later on in the presentation. But for example, in case of a public emergency, for example, like a pandemic, and obviously the COVID pandemic is still quite fresh in our minds, this would be an example where public sector bodies may request access to some of these data to data holders. The third thing we wanted to cover as a third big theme covered by the Data Act is that the Act sets out rules to allow the users of data processing services to switch to other providers, and also it sets out rules to enhance interoperability between the different services. So as I said, these are the three big ticket themes that we will focus on today. However, the Data Act also covers other things, other themes and items, such as, for example, the restrictions to the unlawful access by non-EU government to non-personal data held in the EU, where such access would create a conflict with union law or national law. So it's a bit of a sort of Schrems restriction to the access of data, but for non-personal data. The Data Act also sets out rules to improve interoperability standards for the participants in EU data spaces who share personal data between them with other participants within the data space. And it finally also sets out requirements for smart contract users for executing data sharing agreements. Let's move on to the next slide. One of the things that it's worth looking at is actually what type of data is covered. So the Data Act is quite broad. So it regulates the access and sharing to data rather than just personal data like the GDPR. So the Act sets out a broad definition of data, which I've copied in the slide. I won't read it in detail, but as you can see, it is a broad definition. The Data Act explicitly acknowledges that the data might include personal data. And with regards to personal data, this is defined in the Data Act by reference to the GDPR definition of personal data. Interestingly, there is also a definition of non-personal data within the Data Act, and this is defined by saying that it will be any data which is not personal data. So again, a very broad definition. Just to give you a flavor of the different terms used in the Data Act, in the slide, we have referred to the different types of data referred to in the provisions relating to these three themes that we will be covering today. So as you can see, the data sharing provisions refer to product data, which is data generated by the connected product. It also defines related service data, which is data representing the digitalization of the user's actions related to the use of the product or the service. It also defines metadata, which is defined as a structured definition of the contents or use of the data. And what it says is that in practice, it may be necessary, so it might need to be accessed and shared so that the recipients are able to interpret the product data or the service data that is provided to them. In terms of the public sector bodies' access provisions, they refer to data and they also refer to metadata. And the cloud switching provisions refer to data, and they also refer to another defined term, which is exportable data. And in short, what this is the data generated by the user's use of the data processing service. So as you can see, there are many different types of data and data sets that may be affected under the Data Act. So let's move to the next slide, please. And here we are going to look at the actors. So we've already looked at what's covered, what data is covered. Now we're going to see who is covered. And as you can see, we've set out a list of different actors here. Firstly, I wanted to briefly talk about manufacturers of the connected products and the providers of related services. The role of these different actors is quite self-explanatory. However, it's important to note that non-EA-based manufacturers or service providers may be caught under the Data Act if the connected product or the service is made available in the EU. So again, this rings a similar sort of bell in terms of, for all of you who are familiar with the GDPR territorial scope, this is again a broad scope similar to the GDPR territorial scope of application. Next, let's move on to look at the data holders. This is quite a novel concept. So most of the obligations regarding the making data accessible to users and third parties and public authorities fall on data holders. So it is important for you to determine if you are a data holder or not. The definition of data holder in the Act is broad and is also a bit circular. So data holders are defined as natural legal persons that have the right or obligation to use and make available data, including where contractually agreed, product data or related service data, which it has retrieved or generated during the provision of the service. So as I say, it is a it is a bit of a circular definition. However, the Data Act itself gives us some hints as to who these data holders may be. For example, in some of the recitals. So we can see that a manufacturer may be a data holder as well. Similarly, we can see as well that a provider of related service might also be a data holders. So organizations who make the connected product or the related service available in the EU market and have a direct relationship with the user may act as data holders. So for example, a distributor may be a data holder. As explained earlier, the Data Act has a broad territorial scope, so the location of the data holder does not matter. They will be caught by the Data Act if they make data available to recipients in the EU. So let's move on. This is a good segue to move on to the recipients and who they are. Actually, yeah, let's stay on this slide for another minute or two. So in summary, a third-party recipient is an organization who receives the data from the data holder at the request of the user. And there is a slight confusion in the terms used in the Data Act. So the definition refers to data recipient, but then the relevant provisions in Chapter 2 refer to third parties. But we understand that these are the same. It's just, a bit of a problem with the drafting, but they are the same. With regards to the data users, this is quite a broad concept as well. So what the Data Act tells us is that the data users may be natural or legal persons. So if the user is a natural person and the data set contains personal data, the user under the Data Act will at the same time be a data subject under the GDPR. But if the user is a legal person and the data set contains personal data, then it will be a controller under the GDPR. So one of the things that we are starting to look at as we get our head around the Data Act is the role of the different Data Act actors under the GDPR. So one might think that if the user is a controller, is the data holder then likely to be a processor? And you may think so, but not necessarily. So what we see in Recital 22 of the Data Act is that GDPR processors may not be data holders. So that's expressly set out in Recital 22. However, it goes on to clarify that data processors may make data available to controllers under the GDPR. So as you can see, unfortunately, the Data Act is a bit muddled when it comes to this point of the interaction between the Data Act and the GDPR. And it seems that there is a bit of uncertainty regarding how the Data Act actors and the GDPR actors will interact or will align. So there is some work to be done to get to the bottom of this. If we can move on to the next slide. Thank you. So very quickly, in terms of public sector bodies, as I have explained earlier, these are public sector bodies that may request data holders to make data available to them where there is an exceptional need. And the definition includes the Commission, the European Central Bank, but then also generally other union bodies. In terms of the providers of data processing services, Renzo will tell us about them later on in the presentation and how they differ from cloud providers as such, as defined in the in other regulations under in the EU, in other EU regulations. And there is a slight difference. The concept is not exactly the same. Other actors mentioned in the slide, I won't stop here. I've mentioned them earlier, and some of them also we will provide you more detail later in the presentation. So I leave the explanation of the actors here for now, and I will now pass on to Chloe, who will provide more insights on the data sharing framework.
Thank you, Nuria, and good afternoon, everyone. Yes, as Nuri mentioned, I'm now going to set out further detail on the data access framework. So you'll see on the screen the key obligations, and these are found in Chapter 2, 3 and 4 of the Data Act. And there are also provisions relating to the sharing of data to public bodies in exceptional circumstances, but we'll discuss these further later. So the key obligations are to make product data and related service data accessible to the user. This means that connected products and related services need to be designed and manufactured so that the data is directly accessible to the user. And there are conditions to what this means. For example, the data needs to be accessible to the user without undue delay and to be of the same quality as is available to the data holder. It needs to be available easily, securely, free of charge, and in a comprehensive, structured, and commonly used format. So in summary, the user should be able to directly access the product and service related data. Another obligation is the rights and obligations of users and data holders with regard to access and use in making that available product data. So where data cannot be directly accessed by the user, there are certain conditions on how it should be made available. Specifically, for example, on the basis of a simple request through electronic means. And there's again further provisions on how this should be set out, including contractual restrictions, how the data holder can provide choices to the users, and how the data holder can verify the identity of a user. There are also restrictions on how the user can actually use the data obtained, so not to abuse gaps in technical infrastructure, and conditions on the use of non-personal data by data holders. If the requested data is personal data of an individual that is not the user, the data holder must make that data available to the user unless there is a valid legal basis under the GDPR. And also conditions of the e-privacy directive also need to be fulfilled. There are also rights of the user to share data with third parties, and these are found again in Chapter 2, Article 5. And these rights are to make the data readily available to a third party upon request of a user. And there are conditions again on the format in which this data should be provided. So in essence, this is somewhat like the portability right in the GDPR. And later I will provide a bit more analysis of this in comparison to the GDPR. There are further obligations of third parties receiving data at the request of the user. That's found in Article 6. And the crux of that is that a third party is obliged to process the data made available to it only for the purposes and under the conditions agreed with the user and national law. And there's specific restrictions on third party use. There are also obligations for data holders obliged to make data available pursuant to union law, and they're found in Chapter 3, which sets out a statutory sharing obligations. This includes a framework to apply to a data holder when it is required to make data available to a data recipient or under union and national law. And it provides that the data holder should enter into an agreement with the data recipient, which should be fair and reasonable and with non-discriminatory terms, and it should act in a transparent manner. Now, the data holder can actually charge for making the data available. However, compensation for this in B2B relations is to be non-discriminatory and reasonable. It can be more than the covering costs. They include a margin. And the Commission is obliged to adopt guidelines on the calculation of reasonable compensation. And the Commission is also obliged to publish standard forms of contract for this sharing. Another provision, which is the final one that I'll discuss now, is the unfair contractual terms related to data access, and they're found in Chapter 4. And they're requirements on unfair contractual terms, which seek to address any potential imbalance in the position between different organisations who share data under the Data Act. So any unfair terms, these are those that are grossly deviating from good commercial practice in data access and use and are contrary to good fair dealing. So these are concepts that are familiar in EU law from the unfair terms in Consumer Contracts Directive. Generally, terms which are unilaterally imposed, so they'll not be binding. For instance, the Data Act does set out that terms which exclude or limit the liability of the party for intentional acts or gross negligence are unfair. So the requirement that a term must be unilaterally imposed suggests that these provisions will not apply to negotiated contracts, and the contracting party that supplied the contractual terms will bear the burden of proving that the term has not been unilaterally imposed. So that summarises the data access framework. I'll now move on to how does this compare to the GDPR?
Chloe, just to give people that's an excellent summary of very, very, very complicated provisions, but to give a summary of the summary, people that have product data or have related service data have to make that data available to the enterprise user, potentially enterprise user, have to make that data available to third parties to whom the user wants to send the data, such as someone that might be operating as a service in secondary market. The holder of the data has to enter into a contract with the recipient of the data, and the European Commission will publish standard contractual terms which don't have to be used but will be indicative of the sorts of provisions that they would expect to see. So and I think, as Nuri and Chloe have also already mentioned, there are a lot of ambiguities in the Data Act. there is confusion in relation to its interaction with GDPR, and we'll come back to some of those. There is confusion in some of the definitions as to who is in scope and who is not in scope. And sorry, Chloe, for interrupting you.
No, thank you very much. So you may now be thinking, well, how does this work alongside the GDPR? I mean, some things sound similar, others sound additional. So it is worth pointing out at the outset that the recitals in the EU Data Act do specifically confirm that the Act is intended to complement the GDPR, and that the operative provisions say that if both apply to a particular situation, the GDPR will prevail. So the Data Act also emphasises that personal data must consistently adhere to data protection obligations regardless of the circumstances. However, we appreciate that given the inevitable inclusion of mixed personal and non-personal data sets in practical scenarios, organisations may become apprehensive about the growing intricacy and overlapping requirements arising from these simultaneous application of the two regulatory frameworks. So we set out on the screen as a form of comparative analysis a table between the Data Act and the GDPR, focusing on access and portability rights. So I'll briefly go through this with you now. Firstly, the scope. So under the GDPR, it's the controller who needs to respond to rights requests. Under the Data Act, we are talking about data holders and providers of data processing services, which Renzo will discuss further later. In terms of the territorial scope, now there's some similarity between the two frameworks here, in that it doesn't matter if the relevant company, whether that be the data holder under the Data Act or the controller under the GDPR, is not based in the EU. The Data Act applies to connected products, related services, and data processing services which are made available in the EU. So that means that it applies irrespective of the place of establishment of the data holders. A key difference, which has already been alluded to, is the type of data. So the GDPR, as you'll likely know, applies to personal data and personal data only, whereas the Data Act applies to personal and non-personal data if it falls within the scope of the Act. Moving on to who does it relate to, so next slide, thank you. The GDPR refers to data subjects, so individuals, whereas the Data Act refers to users. So this is wider than the GDPR, as it can be a corporate in connection, a corporate entity in connection with their use of a connected product. Thinking about the time frame to respond to requests, as you'll likely know, under the GDPR, the time frame is 1 month to respond to rights requests, with the possibility to extend by a further 2 months for complexity. Now, under the Data Act, the overarching position is that the data should already be readily accessible and available. However, where it cannot be readily available, it should be provided without undue delay. That's the phrase they use, without undue delay. In terms of the format for responding to requests, there is some similarity here to provide it in an easily accessible, structured and commonly used format. However, we of course appreciate that technically that process of retrieval may be different, and the type of data and scope is also different. So some data will already be readily available, perhaps personal data on a medical device, for example, but others might not be. So taking the coffee example, coffee machine example from earlier, water usage data in relation to use of a coffee machine might not be readily available data. In terms of exceptions, under the GDPR, you can exception to responding to access requests where doesn't have to be provided if it adversely affects the rights and freedoms of others. In other words, a third party, or indeed, even that of a controller. There are also other exceptions too at a local law level. Now, under the Data Act, there are exceptions including regarding trade secrets, intellectual property, or if the data would undermine security or integrity. And there are further exceptions as well if the recipient is a gatekeeper under the Digital Markets Act. So that concludes my summary of the GDPR and Data Act for the purpose of access and portability rights.
Thank you, Chloe. And just to add, I think this is a very helpful way to see the overlaps between the Data Act and the GDPR, and no doubt that we'll all spend the next few months trying to get our head around this. But what it exemplifies is that we will need to plan and set out some processes internally regarding the way in which we manage these requests in practice, because there is overlap, but there will necessarily have to be two different sets of procedures, if you like, for managing these types of requests in practice. So without further comment on this, let's move on to the next slide, which is I'm covering, and it's about the access by public bodies, the access to data. So as I summarized, I gave a quick summary earlier at the beginning. So the data holders may be required either by the Commission, the European Central Bank, or an other union body to share data. This only applies in case of exceptional need in the context of the statutory duties in the public interest of that particular body. So that they will have to demonstrate that there is this exceptional need. And also, what they'll have to demonstrate is that the data is only need to be made available if the data cannot be obtained by these bodies by alternative means in a timely and effective manner. So in terms of the actual request, the request will have to contain certain minimum information, and it will have to be specific. So for example, it will have to include information about the purpose for the request, how long the data will be kept for, how trade secrets will be protected, and so on. Information about, it's quite a long list, information about the security measures that will be implemented, and so on. And the data holder may actually, under the Act, push back and try to refuse to disclose the data on the basis of very limited grounds, but it is still possible to try to push back. So for instance, they might be able to push back when they can argue they have already shared the data with another public body, and these data, as far as they know, hasn't been deleted. Or they could also push back on the basis that the initial request does not contain the minimum information required. in which case they might, the body might need to provide additional information to fulfill this requirement. What the Data Act also says is that if the data set contains personal data, the data holder will have to anonymize it before it shares it with the union body, or if the union body can justify that they actually do need the personal data, the data holder will have to anonymize it. Pseudonymize it. Once the authority has the data, it can only use it and subsequently share it with other public authorities in very limited circumstances in time and scope. So there are limitations once the data is in the hands of the union body as to what they can or cannot do with it. There might be compensation available to data holders who make this information available to the union bodies. And the last point I wanted to make is this point on the micro and small enterprises may be exempt from some of the requests. So without further information on this, I'm going to pass on to Renzo, who's going to talk about the cloud switching provisions.
Thank you, Nuria. So we're moving away from connected devices and moving into the realm of a pure cloud solution, where so no longer Internet of Things, just an online service. And so for the next 10 minutes or so, I'll describe some provisions which are in the Data Act, which could be of or will be of material consequence to some cloud companies. I'll use the word cloud company, but it's not all cloud companies, and I'll come to the definition in a moment. The rationale for the provisions here is to prevent or limit the perceived ill of cloud lock-in, the idea that you have your data in a particular cloud solution and it's just too difficult to get that data out. And that means that you're held over a barrel commercially if you're a user of the cloud solution. And also it means that it is difficult for pro-competitive new market entrants into the sector because customers are too embedded with existing players, and therefore it doesn't help the commercial development of the European Union. Back in 2018, there was some law in this area, well overlooked, and I don't think since it came into force at the same time as GDPR that I ever had occasions to look at it. It set up a scheme for self-regulation. It asked industry to develop codes of conduct and best practices to avoid lock-in. As the recitals to the Data Act make clear, the European Commission, the EU legislator, perceives that mechanism as having failed self-regulation, so is now legislating to fix the failure. And the key point is that certain providers of cloud services, those that provide data processing service, will have to make that data readily available to the user, will have to make that data readily available to successors of the service provision, people that might be replacing that particular provider at the user's bequest, and will have to do so promptly. So there are, and I'll come to them, restrictions on what the cloud company, and I use the word cloud company for convenience, but it's not all cloud companies, will, there are restrictions in what the cloud company can include in contracts in relation to termination, and provisions it must include in contracts in relation to termination. So with no further ado, what does it apply to? It applies to a provider of data processing services, which is as on your screen, a data service that is provided to a customer that enables ubiquitous and on-demand network access to a shared pool of configurable, scalable, elastic computing resources of a centralized, distributed, or highly distributed nature. Pausing there, that's pretty much a fairly standard description of any cloud solution. And we see similar language in things such as NIS2, for example, and other EU instruments. But the key point which makes something subject to the rules I'm going to be talking about or not subject to the rules is that this solution has to be capable of being rapidly provisioned and released with minimal management effort or service provider interaction. So what does that mean? Well, recital 80 gives a clue here and says that the capability of the customer to unilaterally self-provision computing capabilities such as server time or storage without any human interaction could be described as requiring minimal effort. So if you have a cloud solution which simply allows for a click wrap type of procurement, doesn't need a major customization project, doesn't require implementation or expensive or any more than minimal professional services to go with the procurement, then you're in scope as a provider. But if there's going to be more than a minimal management effort, more than a minimal interaction, then you're not in scope. So potentially the big cloud enterprise providers that will negotiate a contract that will, as well as the online solution, have a lot of professional services to go alongside that solution, then they might well be out of scope of these provisions. It's not brilliantly clear, and I've just looked at it a lot over recent weeks and months, but hopefully the guidance, there will be some guidance to make it clearer. So if you are in scope, then there are going to be requirements for the providers of the data processing services to facilitate their switching to another provider or many providers of the same service type or to the customer's own infrastructure. So the obligation to share data with the successor is only if the successor is providing something of the, quote, same service type, quote. And that's another expression I find difficult to interpret. The recitals sort of make clear that when we're talking about data processing services, someone of the same service type might share the same data processing models, might share the same operational characteristics, same primary objective, the same main functionalities, and so on. And then you would be the same service type. But if you don't have the same data processing model, the same distribution model, or the same use case, they might be similar and not the same service type. And if you're similar but not same, then these provisions don't apply. Clear as mud. So again, imagine a situation where someone is buying a well-known customer relationship management system, let's say Salesforce, and wants to switch their data to another one, Monday.com. Those of you in London will see adverts for Monday.com all over the tube at the moment. Is that the same service type as, is Monday.com the same service type as Salesforce? Well, they're both CRM systems, but do they have the same data processing models, the same functionalities? They certainly have the same objectives. So there will be a discussion, I think, to be had, and hopefully, as I say, guidance will come. But if you are in scope of the cloud switching provisions, then all parties must cooperate in good faith, and the providers of the data processing services cannot set obstacles up to stop customers from terminating a contract, engaging another provider, porting exportable data, which we talked about earlier, achieving functional equivalence, or unbundling data processing services from other services. The Act sets out a minimum set of terms that the contract will cover. So again, it's not all cloud companies, but only providers of data processing services. That contract now has to comply with termination provisions that are set out in statute. The customer can give a maximum 2 months notice to initiate the switching service to another provider or in-house. The switching must happen within a maximum of a further 30 days, so 3 months termination in effect, and the agreement will terminate on either that 2 month or 3 month period coming to an end. So for these sorts of in-scope procurements, no longer is there a 5-year minimum term or something like that. There will be a termination entitlement in the contract. If you're in scope, I must add that always. The provider must provide reasonable assistance to the customer, and the third party to switch must ensure business continuity, must ensure security during the process, and must describe what data is actually going to be switched out. Actually, we talked about exportable data a couple of times, but the bullets now set it out in a bit more fuller language. It's the input data that a customer puts in to the CRM, for example, the output data, including the metadata, all of which is generated by the customer's use of the service, but excludes data that's already there, the provider's data, and can exclude trade secrets. But you need to be transparent, the provider to the customer, of what's excluded from the switching provisions. There's an agreed transitional period for post-termination retrieval, again, sort of extending that 3 months. Timeframes can be negotiated by the parties, says the Act, if the provider can technically justify it. Now, this is another provision I find very unclear. If you're only in scope, if there's minimal management effort, that sort of implies, as Recital 80 does, that it's a click-wrap type of solution with no negotiation. So when are you negotiating these timeframes which might be justified? Perhaps at the end of the contract, if the customer wants a longer period, or the provider wants to turn around and say they want a longer period. And at the end of these periods, then the data must be erased from the Data Act. Now, a query arises here, which is, well, actually, what about if it's a regulated medical device, for example, and there's an obligation to keep data beyond the termination of the agreement? GDPR sort of deals with that. Article 28 allows the service provider to keep data for legal purposes, but there's nothing similar in the Data Act. So potentially an oversight by the draftsperson. Other issues in this, and I'm conscious that we're running out of time, so let me try to speed up a little bit. The Data Act encourages the development of interoperability standards. The European Commission is supposed to promote that. The EU standards bodies, CEN and the rest of them, could be asked to draft standards, and they can then be sanctioned by the Commission. If you're in scope of the switching provisions, then the provider can currently charge as long as they communicate that in a contract term. That's a sort of fairly basic provision. But post January 2027, there can be no further charging for switching. There are various transparency obligations on the provider of data processing services, how to switch. An online register must be provided in relation to the data structures and formats, as I said earlier, what's included and excluded from the portability provisions, need to be clear on location of servers, and again, very much like Chapter 5 of GDPR here. And the websites where all that information is set out must be listed in the contract. You can't just put it on your website. I'm going to skip over law enforcement access because we are running out of time. It's just, but very briefly, there's provisions in there in relation to cloud providers providing access to non-EU law enforcement bodies, or adhering to foreign non-EU court orders, which is similar to some GDPR mechanics on that. Very briefly on IP rights, which applies to quite a lot of the stuff in the Data Act, that the data that might be subject to the portability rules and access rules that Chloe described will be potentially protected by an intellectual property, a database right, which is a right which is owned by the maker of a database that's invested a substantial amount in obtaining, verifying, and presenting data. Conscious there might not be that many IP lawyers on the call, but anyway, if there is database right, and of course it won't apply to all data, then that database right cannot be asserted by the data holder to get out of the Data Act obligations. So Article 43, very clear, the database right just simply doesn't apply to product data or connected service data in relation to the access or sharing provisions. Nuria, I'm handing back to you.
Thank you, Renzo. So let's have a look at next steps. I think it's quite clear, from our presentation that this is a complex piece of legislation, so not something that we can get ready to comply with overnight. So we hope that today's session will be useful to you to start familiarizing yourself with the requirements and to form a plan of action. In terms of next steps, our recommendation would be that as a first step, you assess whether you are subject to the Data Act, and if you are, obviously identify your role. So would you be a manufacturer and a data holder, or or so on. We did talk about the actors earlier. So what will your role be? Because that will determine the requirements you're subject to. So then map the requirements and see what is your to-do list, if you like, and then more importantly also look at the having these internal conversations and seeking senior stakeholder buy-in. The data compliance project will need some resource, and so now is the time to secure some budget to put all these measures in place in the months to come. So actions that you're likely to need to do, and this will obviously depend on what applies to you, but generally speaking, if you're a manufacturer, you'll have to review the design of your connected product to facilitate, if possible, direct access to the data. You will also need to look at your procedures for addressing data access and data sharing requests under the Data Act. So you'll probably have to create these procedures from scratch. But at the same time, you're likely to have some standard procedures already in place under the GDPR in order to deal with data subject access requests and data portability requests, in which case you may need to review these or revisit them in order to address any overlaps with the Data Act. There is no question that there'll be some training, internal training required, because there'll be some internal teams that will be dealing with these requests, and they will have to be familiar with the way in which they're dealt with and the procedures that you put in place. In terms of the contractual terms, so we've mentioned this before, but in order to ensure that they cover everything they need to cover and all the requirements under the Data Act, and it's quite a long list, you'll need to review your standard contract terms. And these affects a number of different sets of terms depending on what's your role under the Data Act. So these will affect terms if you're a data holder, so your terms with the users. It'll also affect if you are a data service provider. It will affect your contracts with the users. If you might also have a contract as a data holder with recipients of data, and again, you'll have to make sure you have some standard contract terms that you can use which comply with all the requirements. And also look out for the standard terms that the Commission will issue by September 12th of September 2025. There are also some technical measures you'll need to look at, ensure that you are able to provide access and port data under the required format standards. And also another example is to ensure that you may apply the required interoperability standards. So a long to-do list, yeah, we'll be happy to help you with this. As Renzo said, we are already helping some clients with this, but I'll hand over to Renzo now so that he can provide you a reminder of the timescales.
Thank you, Nuria. So yes, a reminder. It's law. It came into law in January this year with a I think 20 months, is it? I can't do the math. 20-month lead-in time up until September 2025, when most of it comes into effect. But there are some exceptions. The requirement to have designed in data access into products, which one of the key steps that Nuria just mentioned, actually applies from September 26. So you have a little under 2.5 years for that one. There's very, very complicated transitional provision in relation to unfair contract terms, which Chloe talked about earlier, which it takes quite a bit of reading to get your head around it. And I do hope I've summarized it correctly. It's and I don't normally admit things like that, but it really is opaque for drafting in the provision. Those restrictions on unfair contract terms on access will apply to new contracts from the default day of 12th September 25. But if a contract is already in existence as at that date and it's of indefinite duration or have a 10-year duration as from that date, then it will apply only from 2027. So some gaps here, because what happens if you've got an existing contract that's got a 5-year expiration? Well, it seems as if then you need to deal with the unfair contract terms in your contract that you might already have entered into by September 2025. So some complex provisions there which will apply to some people. We've got a few minutes for questions, but I think we have probably stunned you. I see no questions, so let me just wrap up with this is a very important piece of legislation for anyone that's in the IoT space, connected device space, for people that provide cloud services. At the very least, they need to try to make sure that they don't fall within the definition of data processing services, i.e. that there's more than minimal effort needed to procure by a customer. If you are in scope of that, then you begin to need to look at your contracts to deal with the provisions which are there. And I recognise we haven't always been as clear in webinar as we would like to be in our webinars. That is because, frankly, I hope no one from the Commission is listening in. It's not particularly well drafted or crafted. There are lots of ambiguities in the language, not always uncommon in legislation from the European Union, given it's keeps 27 member states happy. But I think this is particularly bad. The interaction with GDPR, the confusion as to whether a data holder can be a processor or can't be a processor, for example. The drafting inserts in one provision a term called cloud computing, which they probably mean data processing service, but they don't. It seems to be a typo. So it's a bit opaque here and there, but we're beginning to get our heads around it and helping our clients. We have a couple of questions. How would it be policed? Yes, good question. The member states do need to appoint a regulator in relation to this. Of course, there'll always be civil redress. If you've got terms which don't comply in a contract, of a connected device or related service or in relation to a cloud computer service that's in scope, then the courts, I'm sure, will give adherence to the unfair terms provisions in here. As to who the regulators will be, we don't know yet. Nuria, chip in if you've heard otherwise. I think we talked about it earlier. It could be data protection regulators in some jurisdictions, but not necessarily. there is already which came about by another piece of legislation, the Data Governance Act, a European Data Innovation Board that's going to provide and help some guidance as well. A question about whether the UK will follow suit. No word on that at all. I don't think. I wish we didn't have Brexit, but every now and again I'm sort of happy that we did when a piece of law which is going to be difficult for operators to actually comply with, both from the customer side and the service provider side, comes along. So I don't think the UK will be following suit in this. So at least I've not heard anything. Right, we're on the hour, so I'm going to call that a wrap. Thank you all for joining. I trust it gave you what you wanted out of today. We will send slides, we will send a link. If you're not already subscribed to our mailing list for events, please put yourself on the list to subscribe to our YouTube channel. We do try to deliver webinars on data and privacy every month or so. Some of you will know we're in the middle of a series on the AI Act. The next one in that series is on AI governance, which is on the 17th of April. And then we've got a non-AI webinar featuring Nuria, but not me or Chloe, on the 19th of June on data in life sciences research. And I hope some of you will be able to join us for that. Thank you very much, everyone.